Case 27, Charas versus Transworld Airlines. We find ourselves, this time, in the U.S. Court of Appeals for the Ninth Circuit. Facts. These consolidated cases caused this court to consider once again the circumstances under which the ADA preempts certain state law claims. Although this court had addressed the scope of this statutory preemption before, they took these cases en banc, sua sponte, meaning of their own volition, to rethink their previous decisions. Robert A. Beveridge was a passenger on a Continental Airlines flight. He claims that a flight attendant hit his shoulder with a service cart and caused him serious injuries, including a dislocated shoulder and a cracked and detached scapular prosthesis. Beveridge filed a state tort claim against Continental for negligence and breach of contract. The district court concluded that the ADA preempted Beveridge's claims and granted Continental's motions to dismiss. Beveridge timely appealed the district court's ruling. Mildred Jacoby was a passenger on Transworld Airlines. After the plane landed, another passenger opened an overhead bin and a large piece of luggage fell on Jacoby's head, causing her injuries. Jacoby filed suit in state court against TWA. The airline removed the case and filed a motion to dismiss. Finding that the ADA preempted Jacoby's claims against TWA, the district court granted the motion to dismiss, and Jacoby appealed. Jerry Charas, a passenger on a TWA flight, tripped over a piece of luggage allegedly left in the aisle by a flight attendant. Due to the fall, Charas claims that she suffered a fractured humerus and required a shoulder joint replacement. Charas sued TWA for negligence. In granting TWA's motion for summary judgment, the district court concluded that Charas's claims were preempted by the ADA. Charas timely appealed the district court's ruling. Bernice Gully was a passenger aboard a small commuter airplane operated by American Airlines. Gully has a bone condition that makes her susceptible to bone fractures. She claims that she advised American of her condition and informed the airline that she needed assistance in disembarking, but that American employees provided no help. Gully exited the plane unassisted on a stairway with only a single movable chain handhold. She alleges that she fell and sustained injuries. Gully brought a state negligence action against American. The district court held that although Gully's claim for negligent failure to provide safe equipment involved the maintenance and operation of the aircraft and was not preempted, Gully's claim for negligent failure to assist her down the stairs involved the rendering of service and was preempted by the ADA. Gully appealed the district court's order granting American's motion for summary judgments. Elizabeth Newman's complaint stems from her attempt to fly from San Diego to Long Island on an American Airlines flight. Newman claims that in making her reservations, she informed American that she was blind, suffered from a heart condition, and required assistance in boarding the plane. She flew from Long Island to San Diego without incident. However, it is alleged that on her return flight to Long Island, a flight attendant attempted to check Newman's carry-on bags due to space constraints. At that time, the flight attendant learned that the bags contained Newman's medications. The flight attendant then informed the captain that Newman might have a disability that would preclude her from flying. The captain asked the flight attendant to ask Newman about her medication and to ascertain the phone number of Newman's doctor to verify whether Newman was at risk for a heart attack during flight. When Newman could not remember her doctor's number, American denied her passage until she could provide a letter from her doctor certifying that it was safe for her to fly. Prior to obtaining the required certificate, Newman was not permitted to board and was required to stay overnight at a motel. She filed various claims, including state tort claims and federal statutory claims, against American. The district court granted American's motion for summary judgment, concluding that Newman's state law claims were preempted by the ADA and that American had permissibly refused boarding to Newman for the purposes of her federal claims. Newman timely appealed. So what is the issue now in front of the Ninth Circuit? Whether in enacting the ADA, Congress intended to preempt only state laws and lawsuits that would adversely affect the economic deregulation of the airlines and the forces of competition within the airline industry. Sitting en banc, the Court of Appeals remanded an action to a 3-judge panel at the District Court. The court held that the Airlines Deregulation Act, does not preempt passengers' run-of-the-mill state law personal injury claims. Let's look into the reasoning why. In enacting the ADA, Congress intended to preempt only state laws and lawsuits that would adversely affect the economic deregulation of the airlines and the forces of competition within the airline industry. Congress did not intend to preempt passengers' run-of-the-mill personal injury claims. Accordingly, Congress used the word service in the phrase rates, routes, or service in the ADA's preemption clause to refer to the prices, schedules, origins, and destinations of the point-to-point transportation of passengers, cargo, or mail. In the context in which it was used in the Act, service was not intended to include an airline's provision of in-flight beverages, personal assistance to passengers, handling of luggage, and similar amenities. The court expressly overruled their decisions in Harris and G to the extent that they are inconsistent with this interpretation. The Ninth Circuit takes an extremely narrow view of the word service, thereby allowing most claims to proceed because they would not be preempted. By comparison, the majority view is that service is extremely broad, thereby preempting most cases because service would fall within a larger bucket of claims. The court reasoned that when Congress enacted federal economic deregulation of the airlines, it intended to insulate the industry from possible state economic regulation. It intended to encourage the forces of competition. It did not intend to immunize the airlines from liability for personal injuries caused by their tortious conduct. Like rates and routes, Congress used service in 1305 in the public utility sense, the provision of air transportation to and from various markets at various times. In that context, service does not refer to the pushing of beverage carts, keeping the aisles clear of stumbling blocks, the safe handling and storage of luggage, assistance to passengers in need, or like functions.